Whistleblowing is in the headlines. Look at the NHS, look at the challenges in America, huge fines. But does it really matter to the private sector? Is it just a public sector issue? Does it matter to in-house lawyers? These are the kind of issues I'm going to address with Simon Stephen, Associate in our employment team. So Simon, why does whistleblowing matter to an in-house lawyer in the private sector?
Whistleblowing is often seen as an HR issue because it involves managing people who blow the whistle, which of course is an important part of the process. But whistleblowing has wider reaches than that, for three principal reasons. One, there's accountability. There's the individual accountability, to whom somebody has blown the whistle. If a wrongdoing is raised to the attention of an individual and nothing happens, and then it blows up into something much more dramatic involving external regulators, then putting it bluntly, heads will roll for that. There's also the wider issue for the corporate itself. Once it becomes aware of a wrongdoing through whistleblowing, there is an onus to do something about it. And again, if it doesn't or it's not managed properly, then that will have an impact on the corporate. The second issue is litigation. An individual, as an employee, could sue the company if they don't feel that they have been treated appropriately, having blown the whistle. There is also the risk of external litigation from external bodies such as the SFO or other regulators or prescribed people, should they get wind of the wrongdoing behind the whistleblowing. And the third issue is public relations. Of course, if a whistleblowing issue hits the press, we have seen this recently with the Rotherham Council and the child safety issues, underneath all of these scandals, there is somebody who says, I blew the whistle and nothing happened, and that is very damaging for public relations.
How does whistleblowing differ from a normal employer-employee grievance?
Whistleblowing and grievances are often seen together because by its very nature both are the raising of wrongdoing. The differences between a grievance and whistleblowing in the context we're looking at it is that grievances are an issue about a very personal nature, about how somebody personally has been treated during their employment. Whistleblowing is something much wider. It is the raising of wrongdoing by an employer, and it could cover any wrongdoing that organisation is doing. It used to be under the case law and the previous legislation that actually the individual's raising of a grievance could in fact qualify as a whistleblowing, but having seen the changes come in last year about the now need for a disclosure to be made in the public interest, this is no longer the case.
As an employer, what are your obligations if somebody whistleblows to you?
There aren't any statutory obligations under the Public Interest Disclosure Act or the Employment Rights Act to do anything proactively with a whistleblower, but there are obligations in terms of how you treat somebody once they have blown the whistle.
What rights or protection do employees have if they air their grievances?
The first point there is the rights and protections extend much wider than employees. It covers workers, and indeed a recent Supreme Court case has held that members of an LLP are covered by the protection as well. But before a worker gets any rights or protection under the relevant legislation, they have to go through a number of hoops to make what is called a qualifying protected disclosure. So they have to make a disclosure of information of a particular breach that an organisation has made, which in short covers any legal obligation, and in the appropriate way. Once they have done that, they have then made what is called a qualifying protected disclosure. Having made such a qualifying protected disclosure, the employee or worker is then protected from being subject to a detriment for having made such a protected disclosure, and they're also protected from being unfairly dismissed.
Are there risks if you don't deal with whistleblowing?
The primary risk is litigation from the actual individual themselves. If they do not feel that they have been managed properly, then they are likely to bring a claim dependent on paying an employment tribunal fee for a detriment or unfair dismissal, should they be dismissed. The wider risk is that the individual takes their disclosure, takes the information of wrongdoing outside external to the organisation to a regulator or what is known as a prescribed body, which is somebody who appears on a statutory list of organisations to whom somebody can blow the whistle. So if an individual is not managed properly, you do have the internal risk, but it also increases the likelihood of this becoming an external issue for which you lose control.
We've heard about the US and how they deal with whistleblowing. Is that going to come over here?
Not anytime soon. There has been a review by the government and public call for evidence, and as part of that, this question was raised, and in short, the government's answer is no. However, the government has recognised that in certain situations it may be appropriate to incentivise a whistleblower by offering a monetary award should there be a successful conviction on the back of it, which is what happens in the US. Alongside with this, the FCA and the PRA are still looking at whether it should be brought in for the financial world and the city in particular.
When will we see changes in the law, and what will those changes look like?
There were wholesale changes made in the summer of last year, and since then there have been a few little tinkerings in relation to extending the list of prescribed people to include MPs, for example, and in terms of the categories of workers who qualify for protection. But we're not likely to see any dramatic changes in the legislation itself going forward as a result of the government's call for evidence. What we are going to see is more of a push onto the prescribed people, the list of bodies to whom people can blow the whistle. They are going to be required to publish annual reports of the whistleblowers that have been made to them. These will be on an anonymous basis, but it's still going to actually require a lot more work for these regulators and prescribed people. And it's going to put more of an onus on them to manage it from an industry or sector area. And what this is likely to do is then push that onus back onto the company themselves.
Is there a key point in-house law should remember when considering whistleblowing?
Whistleblowing for in-house counsel is a very difficult issue because of the complexity of the responsibilities in-house counsel own to the individual they are advising, and also to the employer, the board, to whom they may also be advising, but also to the regulatory authorities and the courts themselves. So very much it can be a situation of being between a rock and a hard place when in-house counsel are presented with facts which present an issue about wrongdoing. So the key point here for in-house counsel is to think very carefully as to their role in whistleblowing, how it is stated in the whistleblowing policy and indeed part of the corporate governance structure, to try and minimise the impact of these myriad of responsibilities they own.
Simon, thank you very much for leading us through whistleblowing and why it's so important to in-house lawyers.
Thank you, David.